Sometimes what goes on in oral arguments is the justices are speaking to each other through the lawyer. So they're asking a question of the lawyer, but they're really trying to sway other members of the court.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hey everybody, welcome to The Defense Never Rests. I'm your host, Trisha Baxter. Today's guest I'm super excited about. You know, the Supreme Court for us is so elusive, so secret, Supreme Court of the United States I'm talking about, that, and it's fascinating. We don't really get a peek behind the veil very often, but today's podcast, we will. And joining us is a former clerk to the United States Supreme Court, Justice Harry Blackmun, who served from 1970 to 1994. He was appointed by Nixon, a Republican, and is notorious for switching and becoming one of the more liberal justices on the Supreme Court. And we're going to talk to her. Her story and experiences are fascinating. So to help me out with that, I want to bring in a co-host, back by popular demand, Nate Bolander. Hey, Nate, how are you?
I'd love to meet the popular demand. I don't know who that is. Good morning, Trish.
So you brought her to my attention. We always kind of brainstorm about the podcast that we want to do. And we always try to think of something differently. And you brought this to my attention. Tell me how and why you did that.
Well, I mean, like you said, the Supreme Court is the pinnacle of our profession. It's secretive. It's elusive. When you talk to non-lawyers, they're into it. It's a topic that I think everyone follows. If you have any interest in politics, policy, the judicial system, this country, you follow the Supreme Court in some way, shape, or form. And when I was a 3L at Penn State Law, I hate to admit, about a decade ago, I was in Professor Kidport's Supreme Court seminar class. Since she's clerked for a Supreme Court justice, it was a class all about the Supreme Court. You acted as a judge for some classes. You obviously went through the history of the Supreme Court. You went through the court when she was on it, the breakdown, how cases come to be on the court, heard by the court. And at the end, you pick a topic that is relevant to the Supreme Court. And, first of all, she is one of the most well-liked, most respected professors at Penn State Law. Everyone tries to get into the class. Everyone really enjoys her. She is just wonderful with the students. But what really stuck with me was that I'm not going to tell you what the topic was, but I chose a topic that I don't think she or the class necessarily agreed with politically. Most of the class members were not on my side in what I chose to do. It wasn't a really embarrassing topic or contentious topic, but I just didn't have the support of the class maybe. And she in the class peppered me with questions and ended up getting a good grade, have a great relationship with her. And she's very intellectually honest, fair. She sparks conversation. She sparks debate. And she's doing the perfect job being a professor. I mean, I think that's what she was meant to do.
So I'm going to let you introduce her then. Who's our guest today?
Today we have the honor of having on the Defense Never Rests podcast, Professor Kit Kidport from Penn State Law and one of my professors when I was there about a decade ago. Good morning, Kit. Welcome to the Defense Never Rests podcast. We're really, really thankful to have you, and we're looking forward to a great episode.
Thank you. Thanks for inviting me.
So is it okay if I call you Kit? I feel like I want to call you Professor. Okay.
No.
So, all right. So Kit, you clerked for the Supreme Court. I think there's so few people that do that. It's so fascinating to me that you have all this stuff in your head about what happened behind the scenes. When did you clerk? What years did you clerk?
I clerked October term OT 81. So I was there from the summer of 81 until the summer of 82. Okay.
What made you apply for that position?
In retrospect, when I was there and saw the application process from the other end, it's sort of like buying a lottery ticket. It's really like winning the lottery. And I have no idea of the hundreds of applications, the justice received, why mine, rose to the point where he gave me an interview. But I was clerking first after law school. I clerked for Judge Abner Mikva on the DC Circuit. And so I just thought I would throw my hat in the ring and see what happened.
So when you got a letter or phone call that you got that interview, what was that like? You must have been ecstatic.
I was still clerking for Judge Mikva, and I was a little bit late to work, and the justice, our day started at 8:00. So he called and I wasn't in yet. And so when I eventually returned the call, he said he wanted to offer me the clerkship if I could get to work on time.
So when you do you have to go to the Supreme Court to interview?
Yes.
So, and I've been to the Supreme Court once, not inside the building, but the steps. And I will tell you, my experience was just, I was kind of humbled. I walked up the steps and I was like, holy crap, like there's so much history, so much happened behind those doors. What was your experience? And you were going into interview. What was your experience like as you walked up those steps?
Yeah, I was nervous. We actually went in the side door. And the first day of work, which is obviously not the interview, but the first day of work, they take your picture and all the Supreme Court guards get the picture and they've memorized who you are within a day or two. So when you walk in that door, they don't, ask you for ID or anything. But when I went to interview, I was asked for ID and then went to the justice's chambers and I sat for a few minutes with the two administrative assistants before I was called into his office. And I found out later that was the justice giving the administrative assistants an opportunity to interview me. And he asked, and then you talk to the clerks. That's pretty standard in any clerkship interview. You speak to the clerks after you speak with the judge or the justice. But he liked to have the administrative assistants put in their 2 cents too. And so I always tell my students, when you go to an interview, every part of it, everybody you talk to is part of the interview.
What kind of questions did he ask? Was it about your resume or was it about your personality or both?
No, he asked about my family, which was interesting. He took notes. He was very meticulous and always took notes. And I had 4 brothers and sisters. And so we went through each one. And then I think he lost track and he forgot about so I thought, I'm not going to remind him so we'll just go on from there. It was more personal questions, like about my family and my background and things like that.
Cool. He was not in his robe? I mean, it was just in a suit or something.
No,
okay, I was going to say that'd be pretty intimidating. I think.
Yeah. No, I was pretty darn intimidated. I'll tell you that. Yeah. No, he wore a suit.
Mm-hmm.
So fast forward, you have the interview. You eventually get the yes from them. You show up at your first day at work. What was that like?
So it was in the summer. They transitioned us one at a time, the 4 clerks, and I was the first one. So the 3 old clerks from the prior term were there, and they helped train me. And what we did over the summer was work on the cert petitions and write memos on the cert petitions because there was no argument until October. So we didn't start writing bench memos on the merits cases until later in the summer. So they sort of ease you in gradually.
So you would get the cert petition. So if for any of our listeners that don't know the mechanics of the court, and well, you tell me, I'm not the guest. You tell me, sorry, I tend to want to talk too much.
So the Supreme Court has discretionary review, which means they have control over their docket, as do many state Supreme Courts. So just because you've lost in the court below doesn't entitle you to a hearing in the Supreme Court. So you have to file what's called a cert petition, a petition for certiorari, and you have to ask the court to consider your case on the merits. And the other side usually files a response, and then the court decides whether or not to grant or deny cert. And if they deny cert, that's the end. And if they grant cert, then the parties write briefs on the merits and an oral argument is held.
So you're starting out by reviewing the applications just to have the Supreme Court say, yes, I'm going to hear your case.
Exactly.
And do you see it before the justice does, or does the justice give it to you with his opinions? How does that work?
So Justice Blackmun was in what's called the cert pool. And at that time, when I first started, there were 5 justices in the cert pool. So that means they took, the time when I was there, the number of cert petitions filed each year was in the 4,000s. So they would take the 4,000 cert petitions or the petitions that had come in that week, and they would distribute them to everybody. But our chambers would write 1/5 of the what's called pool memos. And then the pool memo would be distributed not just to Justice Blackmun, but to the other 4 justices who were in the cert pool. So we sort of shared the load of writing memos on the cert petitions, and you describe the cert petition and the facts of the case and the decision below, and then make a recommendation as to whether or not the court should grant cert.
When you talk about workload, so you talk about workload amongst judges, but is there also workload management amongst the clerks? Like if Kit has 4 going on right now and someone else has 5, you'll take that one, or is it based on what you focus on in law school, or your hobbies or your interests?
No, we would just divide the cert petitions in 4s. So there were too many to pay attention to subject matter or anything like that. When we wrote the justices what's called bench memos on the merits cases, and those were much longer, and those were directed only at Justice Blackmun. So you could tailor the bench memo to, his prior opinions or his prior votes or how you thought, he would decide the case. And for those, we had a very elaborate lottery system where we took turns picking, and that's how we divided up the merits cases.
So were you given guidance? So if you made if you were digesting the cert petitions, and you were making a recommendation, were you given guidance to make that recommendation, or was it just more of your gut? Like, yeah, you guys should hear this.
Yeah, there are Supreme Court rules, and one of the Supreme Court rules talks about the factors that are taken into account in deciding whether to grant cert. The court denies almost every cert petition, so the default would probably be to recommend a denial. And if there's a conflict among the lower courts, then that's a situation where you might suggest that the court grant cert. Often petitions that are filed by the SG's office, the part of the Justice Department that represents the federal government, those are paid special attention when the federal government lost some case and the SG decides to ask the court to grant cert. And then if a federal statute was overturned, that would be a case that might be cert worthy, or if it was a really important issue. But a lot of times the recommendation would be there's no conflict, this is an important issue, but let it percolate in the lower courts. Or this is a fact-bound case. So in theory, the court's not supposed to grant cert just because they think the court below was wrong. That's called a fact-bound case. The law is clear and maybe the court below applied it incorrectly. The court sometimes violates that rule, but in theory, so a lot of cert pool recommendations would be, this is a fact-bound case, deny.
So that's so interesting. Did you ever have a situation where your recommendation, where the judge or the justice disagreed with your recommendation, or?
Oh, sure. There was one of the cases, the year that I was there was the first year, was Justice O'Connor's first term, the first woman appointed to the Supreme Court. And there was a case involving the constitutionality of Mississippi University for Women versus Hogan. And Hogan was a male who wanted to go to nursing school, and Mississippi University for Women had a nursing program, but only admitted female students. And so the question was whether or not that violated the Equal Protection Clause. So I thought that it did. So when I wrote the bench memo to the justice, I recommended that he, vote to overturn the single-sex admission policy. And he wasn't necessarily having anything to do with that. So I sort of peppered him with memos. With Justice Blackmun, if you wanted to communicate something, you did it in writing. So I wrote the bench memo. I then wrote another memo before the argument. I wrote a memo after the argument. When the opinions circulated, Justice Powell was writing the lead dissent. So Justice O'Connor wrote the majority opinion. It was a 5-4 decision, striking down the single-sex admissions policy. And Justice Blackmun was one of the 4 dissenters. So when the first draft of the O'Connor majority opinion was circulated, and then the first draft of the Powell dissent was circulated, I wrote the justice another memo. He still dissented, but he didn't join the Powell dissent, which I had recommended he not join. And he wrote his own short dissent in the case. And he didn't make me write it, which was kind of interesting. He wrote it himself.
And none of this is done verbally. This is all just memos back and forth. Are you seeing the justice during this time?
Yeah, we had breakfast with him every morning. So okay. He ate breakfast in the Supreme Court cafeteria, so the public cafeteria at 8 o'clock every morning. So we met with him, 5 days a week and had breakfast with him for an hour. But there was no shop talk. So he loved baseball. There was talk about baseball or talk about politics or whatever. And then, as I said, and then we saw him, during the day, and we saw him after conferences. So when the court had held conferences on the merits cases, and they went around the table, the conferences are just the Supreme Court justices by themselves. There's nobody in the room with them. But the justice took notes on all the cases and all the conferences, and we would go into his office after he came back from conference, and he would tell us how the cases had been decided and what the various justices had said during the conference.
Did he ever share more than that? Did he ever share, personalities and if there were arguments and things?
Oh yeah, he did. Yeah, he
Must be
did.
Interesting.
Do you remember any of them stand out to you more than others? Or that you can talk about? I don't know. Can you talk about them?
Well, one thing about the justice, as I said, he was extremely meticulous. He was a math major. He took copious notes. And for each merits case, he had, 8.5 by 11 piece of paper. And on each side, it was divided into 4 squares. So that was for each of the 8 other justices. And so he would write down for each one, and their initials were at the top, what they had said and how they had voted. 5 years after he died, he donated his papers to the Library of Congress. And that's not unusual, although some justices destroy their papers. They don't donate their papers. That's not unusual, but it is unusual to make them public 5 years after your death. That's pretty soon. And there are more than 1,500 boxes of materials of Blackmun papers in the Library of Congress and more than 500,000 documents. And it wasn't just like they dumped everything from the office on the Library of Congress. They went through it and weeded out, what they didn't want to include. So anybody can go to the Library of Congress, and for each of those cases, he was on the court for 24 years. For each of those merits cases, you can find that piece of paper where he took notes about what happened during the conference and what the justices said. So it's an invaluable resource for people who want to do research on one of the cases that was argued during his tenure on the court.
I think that's so fascinating because, you think of the justices as untouchable or, you can't really, besides what they write in the opinions, that you really don't get a sense of what's going on in their head. So I didn't even know about that. That's awesome.
Yeah. So if there's a case that you're interested in, you can, there's an elaborate system of cataloging, and you submit your request and they bring you out the relevant documents.
When you said it was odd that Justice Blackmun donated his 5 years after death, was it odd because most do not at all, or most wait 20 years?
A lot of people wait. A lot of justices wait until everybody they served with had died. And some, I forget who it is. One of the recent justices, I think it's 50 years after his death. So 5 years is really soon. And then for the Brennan and Marshall papers are in various places, but they're not as detailed. So obviously they're important, valuable resources, but they don't have the same level of detail in all the cases like the Blackmun papers do.
Can you speak to when you were on the court for that year, you clerk for the court for that year, the professionalism between the justices? I have this sense that they disagreed a lot, but they probably did it in a very academic way. What was your experience?
That was my sense. They did disagree. They didn't socialize. The 9 justices who were there. They didn't walk back and forth between offices. Every once in a while, Justice Brennan would call Justice Blackmun on the phone. But Justice Blackmun didn't wander around the chambers. They saw each other during the conferences. But the court has sometimes been described as 9 independent law firms that operate independently. And that was sort of true. I mean, we didn't roam the halls either. There were some clerks who would roam the halls and talk to the clerks in the other chambers, but we worked really hard. Justice Blackmun was the hardest working justice at that time. And he was 73 the year that I was there. And we worked the hardest. I'm not saying that to brag. I mean, we just did.
What are the average ages of the clerks about? I mean, is it mid-20s, late 20s?
Yeah, so it's usually, it varies some, but usually it's your second year after law school. So the first year you usually clerk, first year or 2 after law school, you usually clerk like I did for a different court, and then you apply to the Supreme Court.
The reason I ask is because if you're in your 20s, maybe there's like some fraternizing, all the clerks go out together. I mean, I think it's less likely if you're 40 something with children, but I mean, maybe in your 20s, was there a lot of party animals on the clerks? I imagine they're pretty serious people.
Yeah, they were pretty, we ate lunch together a lot. Most of the clerks ate lunch together in that same dining room at the Supreme Court that I mentioned. But the four Blackmun clerks my year were really close, and we socialized, but we didn't do a lot of socializing with, there were a number of clerks at the court who had been on the DC circuit when I clerked on the DC circuit. And that year we did do a lot of partying and going out after work on Fridays and whatever. So some of those friendships, you know, I maintained, but I didn't do a lot of socializing with I didn't have a lot of time. I worked pretty much all the time.
And what were your hours like? Oh, sorry. Go.
No, that's exactly what I was going to ask.
Yeah,
you and I are on the same page.
Yeah,
Nate.
what are your hours like on it? I mean, if he's there at 8, you got to be there at 7. I mean.
No, we got there at 8 too. We got there
Okay.
at 8 to eat breakfast. And we started work at 9 after breakfast. And we had at that time a very rudimentary computer system called the ATEX. And the ATEX closed down at midnight. So I had one co-clerk who was married and who was way more efficient than the rest of us. So he would often leave to go home and have dinner with his wife. But the other 3 of us were there until midnight. And on Sundays, the ATEX didn't start running until noon. So we worked 7 days. We worked basically as long as the computers were running, and then we would go home and read things. So we literally worked all the time.
What do you think you took away from that experience personally the most?
Well, there was a lot to admire about the justice. He had a very close attention to detail. As I said, he was a math major. He'd been a tax lawyer. So I think that when we would review the pool memos that came from the other chambers before giving them to the justice, and then we would write on the bottom our recommendations to add to the pool writer's recommendation. And the justice, if we gave him bench memos or pool memos, he would circle the typos. So when we would read the pool memos from the other chambers, we would circle the typos. So that attention to detail was something that I admired in him, and that I think I took away from him. Another one of his characteristics that I really admired was his humility. He introduced himself as Harry Blackmun. He didn't introduce himself as Justice Blackmun. He liked to call himself Old Number 3 because he was the 3rd nominee for the seat. The Senate rejected the first 2 nominees. And then when Justice Kennedy arrived on the court, Justice Blackmun alleged, he told us that he wanted to welcome Justice Kennedy to the Old Number 3 club because Justice Kennedy had also been the 3rd nominee for that seat. But the justice wasn't sure that Justice Kennedy appreciated that.
It sounds like he had a sense of humor.
He did have a sense of humor. Yes, he did have a sense of humor. And he was very kind. He was solicitous of his staff. As I said, he wanted to know what everybody thought about the clerkship applicants. I don't know why, I can't remember what had happened or why I even thought this was a good idea, but once he had left the office, which was unusual, he didn't usually leave the office, and he had a sofa in his office, and I was really tired. So I lay down and took a nap, and he came in. And I was just so embarrassed, but his first reaction was to apologize for waking me up. But I never did that again. And I don't know why I had the guts to do it in the first place.
Well, if you're working till midnight, he's got to understand you're pumping out work for him. So it's good that he's humble that way, because I think when you get to that level, I mean, that's the pinnacle of the legal profession. I mean, I imagine some justices, and I imagine you probably interacted with some where your co-clerks did, that were the opposite.
Yes,
Yeah.
yes.
And I won't ask you more than that. I don't want to,
Okay.
I don't want to go any further than that.
So, and you mentioned this before, that he didn't really socialize as much with the other justices. And you hear like the infamous story of Justice Ginsburg and Scalia that had that really close relationship. And it's so fascinating to me because they're so polar opposites. At least I had that perception. They're so polar opposites in their views. So the fact that they got along so well is so intriguing. I guess that's probably wasn't your experience with Justice Blackmun. He probably stayed to himself.
No, and I think that was, I mean, I obviously don't know about the other justices' social lives, but he did pretty much stay to himself. And I think part of it is, Justice Scalia and Justice Ginsburg had developed that friendship while they were served on the DC circuit together. And they were both opera fans. So that was, I think, one of the things that that generated the friendship. But I think with the justices, as you said before, you know, they disagree. They have a lot of important decisions to make. And I think they like to maintain their independence. And so if you're really close, obviously that didn't affect Justice Scalia's votes or Justice Ginsburg's votes, but I think there's some concern that, you know, it's natural not to want to disappoint your friends. And so I think there was a sense that they maintained sort of a independence. They were cordial, they were professional, but not friendly so much.
So when they conference those cases, the justices together, how long are they in there? How many cases do they do at once? Is it all day?
No, it's not all day. They conference they have cert conferences and then they have merits conferences. So the cert conferences are, they don't discuss every cert petition, but there's a quote discuss list that lists the cert petitions that are going to be discussed at the cert conference. And there they vote on whether or not to grant cert. And then there's the merits conferences, which are the conferences on the cases that are heard for oral argument. And those are on Friday. So it would vary how long the conference took. And I think it depends a lot on who the Chief Justice is. You know, when Justice Rehnquist was the Chief Justice, he was very efficient and he wanted the trains to run on time. So things happened more expeditiously than they did when Chief Justice Berger was the chief, which was when I was there.
If you followed a case kind of from its inception or when cert was granted until the time it was discussed on the merits, when Justice Blackmun came back from that conference, was everyone real giddy to hear what had happened? I mean, were you nervous to hear?
Absolutely. Yeah. You know, it was you know, whether you'd worked on the case or not, it was always fascinating to hear what the justices had said at conference.
Because you know the national or international news had just been made, you know, and you're one of the first people to find out. That must be really neat.
Yeah. And we got trained from the very first day, drilled into us was the confidentiality. Because obviously you can't discuss your work. And lawyers, you know, unlike the district court level where lawyers call the clerk's office all the time, it's considered inappropriate for a lawyer to call a Supreme Court justice's chambers or for certainly the press. They call the clerk's office or they call the press office, but they don't call directly.
It's got to be hard to keep that confidentiality. Like, you know, a couple things that stick out at me as far as what Justice Blackmun has done over his career. One is obviously Roe v. Wade. I can't imagine being the person who's writing that in that political environment, the clerk, and having to keep your mouth shut. Was that hard?
It was hard. It was hard, but you knew how important it was, you know. And there were no huge blockbuster cases the term that I was there. I mean, there were some important cases. There were obviously really interesting cases, but there was no big abortion case that year. There was a death penalty case. I'm not sure it's one of the most well-known cases about whether or not it's constitutional to kill the getaway car driver, to execute the getaway car driver, you know, in a felony murder case. But there were no, it wasn't a blockbuster term, I would say. And I certainly wasn't, you know, the relationship, there's no secret to this. The relationship between Chief Justice Berger and Justice Blackmun was not the best. They were both from Minnesota. They'd been friends or acquaintances in their early life. But Justice Blackmun had become much more liberal during his tenure on the court than the Chief Justice. And so Justice Blackmun thought that the Chief Justice assigned him the Blackmun chambers, the less interesting cases. So,
did he ever talk about his switch? Because he was appointed by Nixon, obviously Republican, which makes you think that he started conservatively, and then he becomes one of the most liberal judges on the court.
Yeah, and by the time I got there, he was certainly in the liberal wing. You know, in 1981, he started in 1970, and I think he was more. You know, he was appointed, you know, on a law and order platform. You know, that was Nixon's big issue. Not abortion. So maybe the Roe v. Wade issue is not something that should surprise us. And he was initially very conservative on law and order. And when people talked about sort of the conversion of Justice Blackmun, he liked to say that he hadn't changed, but the court had changed under him. He said that all the time. And I think that was true to some extent, but it also I think he did change. And that's another thing that I thought was, that I took away from the year that I really admired about him. You know, he was in his early 60s when he became a Supreme Court justice. He was 73, you know, when I clerked for him. And he did change in the 24 years on the court. You know, one of the early cases in his tenure on the court was Furman versus Georgia, which was a 5-4 opinion striking down, at that time, every existing death penalty statute in the country. And Justice Blackmun was in dissent. He would have upheld the constitutionality of the death penalty. In his last term on the court in 94, he wrote a dissent from denial of cert. So the court was denying cert. They were refusing to hear the case, and he was dissenting from the refusal to hear the case on the merits in a case called Callins against Collins. And he famously said, "From this day forward, I will no longer tinker with the machinery of death." And he wasn't of the view that Brennan and Marshall were, that the death penalty is inherently cruel and unusual punishment. He just thought it's administered in a capricious way. There's so few people who get sentenced to die, the racial disparity in terms of usually the race of the victim in terms of, you know, who gets sentenced to die. And so he, you know, that was a 180-degree switch from Furman, where he said, I'm going to vote with the defendant in every death penalty case.
When you were clerking for him, did he ever share with the clerks that he regretted a prior decision, or if you kind of put a previous opinion of his in front of him, did he say, "Oh, I don't know if I really still am about that one"?
No, I don't remember him ever saying that. I certainly think there are some he might have voted differently in later years than he did in early years, but he never expressed regret that I recall about his vote in Furman or any other previous case.
Do you think it was the court that changed him, or society, or something else?
I don't know. He denied that he changed, so you couldn't really ask him. I think it was, you know, when you get to the Supreme Court, you know, there's nobody above you, right? So you can pretty much, you know, make your own decisions. You're not, technically they're supposed to follow precedent, but they're not bound by precedent. So there's a freedom that you have. You've got life tenure. So nobody's going to vote you out of office. You know, nothing President Nixon can do, you know, if his nominee turns out to not be so conservative on law and order anymore. So I think there's a freedom there that you don't have when, you know, for example, when he was on the Eighth Circuit, although Justice Marshall liked to say that he knew that Justice Blackmun was a closet liberal because on the Eighth Circuit, he had written a prisoner's rights opinion that was fairly liberal. So Justice Marshall sort of agreed with Justice Blackmun that the court changed under him.
Did you ever see the justices waiver based on public opinion? I mean, I know now it's commonplace for, you know, protests to be outside the Supreme Court on decision days and oral argument days. Were they pretty kept away from media? I guess I was going to say social media. That's not an issue back then. Regular media and public opinion, or do you think they were independent in that way, or do you think it did sway them?
Certainly, nobody ever said that it swayed them. You know, there are people who, you know, academics who think that the court maybe there's a lag, but that they do follow public opinion. You know, they're all people, right? And so they have their own political views, and as views change, you know, you think about, you know, same-sex marriage, right? You know, the country has changed its view on that. Certainly young people have changed their views on that, and the court, you know, maybe was behind other people, but eventually they came around. And I'm not saying that that's impermissible. I think that's sort of logical and to be expected that they would have views and that those views of the justices would change over time.
Okay.
So let's talk about the timeline of a case. So, because I don't know if I fully understand all that goes into it. I mean, it takes a while. It's a process. So let's start from when you first received the cert petition. Walk us through what happens. So
we receive the documents when they're all together, right? So the clerk's office holds on to the cert petition until the response has come in, or the time for filing a response has elapsed and it looks like there's no response coming in. And then we get the cert petitions and we write the pool memo. And then the pool memos get circulated to the justices who are in the pool, which at that time was Justice O'Connor became the 6th when she joined the court. So at that time, there were 6. And then the court holds its conference on the cert petitions. And sometimes they dispose of the case at the first conference, and sometimes they don't. Sometimes they relist it for sometimes weeks. The SCOTUS blog wasn't around when I was clerking, but now SCOTUS blog keeps track of the relisted cases, the cases that the court, has held on to for a while. And then the decision is made to grant or deny cert. And if cert is granted, then the merits briefs are filed and oral argument is scheduled.
So let me just stop you right there. What's the time frame from when the clerk gets all the cert petitions until cert is decided?
It depends. It takes a while because it takes
like a year or two?
No. And over the summer they don't have any conferences, so the cert petitions and the pool memos pile up over the summer, and then they hold right before the first Monday in October. They hold what's called the summer conference, and that can go. It would be a couple days under Chief Justice Berger. Under Rehnquist, it would be 1 day. So they discuss the cert petitions from the summer and grant cert on those. So it sort of depends on what, when your case was finalized in the Court of Appeals or the state Supreme Court, how long it's going to take, and if the summer falls in there.
So what would be a reason that they would relist? Is it they want to think about it more? They want to do more research? The wrong time?
I don't know. They don't explain. Nothing gets explained. Sometimes they just don't know. When Justice Rehnquist was Chief Justice, it was reported, I don't know if it's true or not, that he would relist. It takes 4 votes to grant cert. But Justice Rehnquist thought he wasn't one of the people who voted to grant cert a lot. So it was reported that he would relist cases even though they had the 4 votes to grant cert, and hope that somebody would change their mind. I don't know if that was true or not, but
it's a great story, though. Yeah. So then, if it's denied, then the parties get word it's denied and it's over. If it's granted, what's that like? You get word that it's granted. Are there I would imagine if it was my friends, I'd be like, oh my God, can you believe that they're going to hear this? This is great or this is bad. Did you have those conversations?
No, I didn't have those conversations. You mean the lawyers would think it was great that their case cert was
or just
granted?
the clerks? I think I would want to gossip a little bit with the other clerks.
We did. Yeah, we did gossip about the cases on which cert was granted. Yeah. Certainly we did that.
All right. So then it's granted, and then you started, and I interrupted you. I apologize. And you started to say, then the merit briefs are filed. So let's pick up from there.
So then the merit briefs are filed, and then amicus briefs, any friend of the court briefs, are filed with around the same time as the merits briefs, and then oral argument is held.
And one of the questions, maybe you can explain what an amicus brief is to the audience as well. But my question is always, I guess there's no limit, right? I mean, now cases have, I would say, tens or hundreds of amicus briefs. Are they considered by the clerks as well?
Well, when I clerked, when I was writing a bench memo, I would read all the amicus briefs and I would, summarize them. But there's certainly a growing number of amicus briefs. Amicus is from the Latin friend, so it's a friend of the court brief. So if it's a state criminal case, for example, the SG might file an amicus brief on behalf of the federal government. Or if it's a federal criminal case, the states might file an amicus brief on behalf of the government. The ACLU, the NAACP, organizations, the American Psychiatric Association, organizations might file amicus briefs. And there's, I think the record, or at least one of the recent records, was the first ACA case. And there were more than 130 amicus briefs filed in that case. I can't imagine, a clerk would read 136 amicus briefs. A lot of times they're redundant, which is one of the problems with amicus briefs. And so maybe you'd read the ones, sometimes law professors write amicus briefs. So maybe you'd read the ones that were written by somebody who you respected, or certainly you'd read the SG's amicus brief or the state's amicus brief. But I don't think you can read 136.
No.
Oh God, it would take you probably years. So do you remember how many certs were granted during your term?
So during my term, that's something that's changed, in the time since I was on the court. They granted cert in more than 200 cases, and they heard more than 180 arguments, and they wrote signed opinions. So a majority opinion that was signed by one of the justices, not a per curiam opinion, by the court. They wrote 169 opinions that term. Today, it's 100 fewer. So the current court grants cert in way fewer cases. This year, because, of coronavirus, they're going to be fewer than usual because they suspended oral arguments. But in the OT 18, they had 73 arguments and they issued 66 signed opinions, whereas in our term, it was 169. So that's a huge decrease. In 2016, they issued 61 signed opinion, which was the lowest number since 1953.
Wow.
So last term, in the 2018 term, each of the justices wrote 6 to 8 majority opinions. And if you don't do a lot of concurring or dissenting, like Justice Kagan and the Chief Justice don't write a lot of separate opinions, the Roberts and the Kagan chambers wrote 12 opinions in total for the whole term. So that's 3 opinions per clerk.
Well,
how many did you write? Sorry, Nate. How many did you write?
I can't remember, but a lot more than that.
I was going to say, hopefully these clerks today are watching and they're hearing Kim Ford sleeping on couches, until midnight. Get with it,
They do have more cert petitions than we do, although the number of cert petitions has gone down in recent years because it's just so hard. When the year that I clerked in the 80s, they were granting about 4% of cases, granting certain 4% of cases. Now it's less than 1%.
And there's no limit to that, right? I mean, there's no gateway to get to the court. I mean, if you, anyone can file a cert petition. Is that correct?
That's correct.
Yeah, I mean. Yeah.
So why do you think is the biggest decline because there's less cert petitions, or are there other things at play?
No, there are more cert petitions. There were, they numbered in the 4,000s. In 2006, there were almost 9,000 cert petitions filed, and now it's leveled off. It's in the 6,000s.
But they're granting less, even with more. Would you know why that is?
There are various theories. Justice White is no longer on the court, and Justice White was one of the people who thought that the court's job was to resolve conflicts. And so if there was a conflict in the lower courts, Justice White routinely would vote to grant cert, and nobody has really replaced him. So I think somewhat it's the justices are less willing to grant cert or think it's less important to grant cert than some of their predecessors did. Some people think the federal judiciary has become more conservative, and so the federal government loses fewer cases, and so there are fewer SG petitions, and the court pays a lot of attention when the SG files a cert petition, because the SG's office is famous for being a pretty good gatekeeper and not just filing for cert in every time the federal government loses a case. So even though the Justice Department lawyer who lost the case might want the SG's office to file a cert petition, a lot of times they refuse to do it. So the court pays special attention to the SG petitions. Nobody really knows. It just sort of happened.
That's fascinating. I want to go back to the oral argument part because this fascinates me. I would imagine I would be petrified as a lawyer walking in and looking at that scene and arguing. I have mad respect for people that do mad respect. Mm-hmm. It's like they should be like they're in the Olympics. Did you get to sit in on the arguments?
Yes. So it is. It's a very, you can look at pictures of the courtroom on the Supreme Court's website. It's a very grand room. It's very intimidating. The justices are in these big, leather chairs. One of my co-clerks has done a number of Supreme Court arguments. He was in the SG's office for a while, and he said one of the things you don't realize is how close you are to the justices, the lectern where the advocate stands. But if you look at the courtroom sort of from the rear, and you're looking at where the justices sit at the bench, to the right, there are just outside the courtroom. There's some curtains and sort of doors with gaps in between, and there are some chairs there, and that's where we sat. So you could go in and out. So you could go hear the case, that was your case or a case that you were particularly interested in. But you wouldn't disturb anybody and nobody would notice if you left.
That was one of my questions. You knew which ones you were going to be assigned because you've got the briefs in. So would you work it out with your clerks? Like, hey, mine's going to be today at 10 and you can go at 11 and we'll have coverage the rest of the time.
Right. We wouldn't always go, if I think usually we went if it was our case was being argued. So you're right. We divided the merits cases into 4 because there were 4 of clerks with that elaborate selection process that I told you about. And then we wrote the bench memos in 1/4 of the cases. If it was your case that you'd written the bench memo on, you usually went to oral argument.
Did Justice Blackmun know his decision walking into oral argument?
I think he had, I think what they say about oral argument is you can lose a case in oral argument, but it's hard to win a case in oral argument. The justices today are very active, much more active in questioning advocates than they were the year that I clerked. And Justice Blackmun was not one who asked a lot of questions. I think to the most extent they do know how they're going to vote. But, they have a lot of questions. They just instituted this term, a 2-minute rule, which some of the lawyers like, some don't, where you're not supposed to ask a question during the first 2 minutes of the oral argument.
So they get to focus on what they can say for the first 2 minutes. They need to get out the most important stuff.
Right.
So, and this is no comparison to what you did, but I clerked for an appellate court judge in Pennsylvania, and we got to attend argument. And I could tell by the silence that during argument when people had made up their mind. And then I could tell by the heated exchange when people were changing their minds. What could you tell by the participation when you sat through the cases that you wrote up?
Well, there was also a lot of difference in the lawyering then. In the times, in the last 25 years, there's been the emergence of what's called the Supreme Court Bar, which are lawyers who specialize in Supreme Court work. And the SG's office is obviously an example of people who do, a lot of Supreme Court work. That's not all they do, but they do a lot of it. But the year that I clerked, if you left out the SG's office, and there are a lot of arguments, remember that term, fewer than 20% of the lawyers who argued had ever appeared before the Supreme Court before. That was their first argument. And now there's a pretty well-accepted definition of a Supreme Court specialist that an academic came up with. So according to that definition, in 1980, 3% of the lawyers who argued were Supreme Court specialists. And today it's like 70%. And in the 1819 term, just over 50% of the lawyers who argued had another argument that same term. And that was unheard of, when I was there. So I think the quality of the arguments is probably better. To go back to your question about oral argument and the silence, Justice White, if he got aggravated, he would turn his chair around. So all you would see, it's this big black chair. All you would see was the back of the chair. So you knew he wasn't happy with your argument.
It's like that's like the Voice, isn't it? You turn around if you're happy or unhappy. Yeah, it's pretty. Right. That's how that works.
Yeah.
Yeah, well, now, it's commonplace to have justices ask several questions. I remember when I watched some Supreme Court arguments or listened to them with some non-attorneys, the person would begin speaking and they'd be immediately interrupted. And my friends would look at me like, what the heck? He hasn't got his argument out yet. I said, he or she is physically below the justices and, in terms of the structure and system below the justices. So they run the show, and the interruptions must be pretty hard to deal with.
Well, when I've read a little bit about the 2-minute rule, and some lawyers say it's a waste of time because the whole point of oral argument is to answer the justices' questions. Mm-hmm. We've written our brief. You're not supposed to repeat your brief. They've read the brief. So I want to answer the questions that they have, and I want to try to convince them. And I don't really need to spend 2 minutes at the beginning summarizing. Sometimes what goes on in oral arguments is the justices are speaking to each other through the lawyer. So they're asking a question of the lawyer, but they're really trying to sway other members of the court.
And I've seen justices save the litigant before. When they get asked a tough question from one side, the person will lean forward and kind of hold their hand up and say, I'll take this. And it's, you can tell where each of them stand, obviously.
Yeah. And they're, with the, except for Justice Thomas, right, who rarely asks a question. Although interestingly, he did ask questions during the recent teleconference, the cases that they heard by telephone in May, because the Chief Justice would just go down the row and he would call on them. And Justice Thomas did participate. But aside from him, they're all pretty active questioners. And sometimes the Chief Justice has to point, has to sort of run interference and point at who gets to ask the next question because they're interrupting each other.
Mm-hmm.
What did you think of the lawyering when you were, I have this impression that it's like the Olympics of lawyer. It's like all of the best lawyers that have the ability to be on their feet in ways that maybe the rest of us don't. That's the impression that I get. What was your impression of the people that you saw arguing?
And I think just from what I've read, obviously I know more about the term that I was there. I think there was a lot of variety. So Larry Tribe argued a case, a desegregation case, and that wasn't my case, but that was a case a lot of clerks went to listen because he was, a famous Harvard law professor, and he was quite good. And there were some who were really good, but there were some who weren't particularly good, and would have benefited by, somebody in the Supreme Court bar, had it existed then, doing the case. I had a friend who practices in Illinois, and she had a really sad child sex abuse case. And it was a civil case. She was suing a school district, and she lost in the Seventh Circuit. And lawyers were calling her up. Saying, we'll represent you if you want to file a cert petition. We'll take your case pro bono. Lawyers from big firms were sort of trolling through the Federal Court of Appeals docket to figure out what were maybe cert-worthy cases, and then offering to do them for free.
They went to the PR? Is that or the experience?
Yep, the experience and the PR. Mm-hmm.
That's crazy. For the lawyers, I'm just so curious about this. For the lawyers that maybe didn't do well, did you see the justices like annihilate them, or were they kind, or like did they ruin their chances? What's your impression of that?
I think it varied from. I think that's a personality. Yeah. Depended on the personality of the justice. I mean, Justice White was known to be, pretty aggressive, and so he could question aggressively. And as I said, when he got really aggravated, he would just turn his chair around. But others of them were, Justice Blackmun didn't ask a lot of questions. He was always very kind. Justice Brennan was a real sweetie.
You were on there, I think you said when Justice O'Connor came on, right? Mm-hmm. Was there anything different about the presence of a woman? Did you notice any difference about that?
I didn't, but I have nothing to compare it with, right?
Yeah.
So for a long time, fortunately before Justice O'Connor was nominated, for a long time, the justices were referred to as Mr. Justice. And they dropped the Mr. Sort of, I guess, for seeing the writing on the wall a few years before her nomination. So their formal name was just, Justice.
That's so fascinating. I know we're running short on time, and I wanted to get to this topic. You've touched upon some of this throughout the podcast, but the changes over the years. I mean, we talked about the emergence of the Supreme Court bar, which I think is probably welcomed, right? If I had a client that had a case to go to the Supreme Court, I would want to hire a specialist. So I think that's great. And then the decline in the number of certs that are granted. What other changes have you seen?
The court has gotten a little bit more open. It's very secretive for the reasons that we discussed. But it is interesting that they were live streaming those teleconferenced arguments that were held in May. For years, the court has resisted having cameras in the courtroom. And there have been several senators, Arlen Specter from Pennsylvania was one of them, who was a big proponent and would introduce legislation requiring cameras in the courtroom. And the Supreme Court has been very resistant to that. And for example, the Supreme Court of the UK, they live stream on TV their oral arguments. So it's not unheard of. Some court of appeals in this country are experimenting with televising their oral arguments. But in the last, under Chief Justice Roberts, they've released the transcripts of the arguments more quickly. So the transcript is available the same day as the argument, and then the audio is available on the Friday after the argument. Arguments are held Monday, Tuesdays, and Wednesdays in argument weeks. And so on Friday, the audio gets released. So there's still no TV, but they're a little more open than they were. I don't know if I suppose maybe at some point there will be cameras in the courtroom, but.
And what's your personal opinion on that? Having clerked there, do you think it would be a good thing for the public to see?
I don't know. I think some people are afraid that that would affect the lawyers and the justices, that they would play to the camera, or that, and that the arguments would be, spliced and taken out of context on the news. So there's concerns about that. You could do that with audio, with a transcript, but maybe it's less likely to happen. I don't know. I guess I'm of two minds about it. It certainly would be a good educational tool for the public to be able to watch these arguments.
I've listened to a fair bit, and when it says the justice's name at the bottom and it has kind of the subtitles, it really is helpful. But there's nothing like seeing body language and seeing who's leaning forward, who's looking at who. And I do think it would be, I get the secrecy around the Supreme Court and the reverence, but I do think it'd be a good public service to make that available.
Yeah, I think that's a good point.
Yeah.
There's one of the other changes is the growth in the cert pool. As I said, for the cert pool started in 1972. It was Justice Powell's suggestion. And it had, from the beginning until the term that I was there, it had 5 participants. Justice O'Connor was the 6th. And then for many years, there were 8 justices in the cert pool, everybody but Justice Stevens. And in 2008, the beginning of the term in 2008, Justice Alito dropped out of the cert pool. And some people, there was no explanation, of course, but some people surmised that he foresaw that Justice Stevens would retire, and he didn't think all 9 justices should be in the cert pool. So Justice Stevens retired. Alito stayed out of the cert pool. Gorsuch is not in the cert pool. So now there are 7 justices in the cert pool. So some people think that's a negative change, that now there's only one person in the courthouse potentially who's reading the cert petition and then writing a memo to now 7 of the justices, and for a long time, 8 of the chambers. So obviously you have the cert petition. You can read the cert petition if you're a justice or if you're a clerk in the chambers who's not writing the pool memo, but there's so many of them that unless there's some red flag, chances are you probably aren't going to read the cert petition. So
you're probably just reading this, you're reading the cert memo and more relying on that than the documents themselves.
Exactly. Yeah.
And then that chamber's subjectivity could affect whether a cert is granted in a case. Yeah.
So I have this impression, and I want you to correct me if I'm wrong or get your opinion of this. It seems to me that the court now is slightly more political. Do you get that sense, or you think they're not? They've stayed out of that.
Oh, I think the court has always been political.
Okay. Even when you clerked, you saw the politics behind the decisions and things like that.
Yeah, I think you could not on all the cases, but on the big blockbuster cases, you could probably predict how most of the justices today will vote. And you could have at the time in 1981 when I was clerking on the Supreme Court, you could pretty much predict who would vote which way. They're the conservative justices and they're the liberal justices. And sometimes there's a sort of odd division among them. But a lot of times it's pretty predictable, I think. But I think that's always been true. And I don't necessarily see anything wrong with that. I think that's human nature.
Yeah.
How do you feel about the breakdown of the court politically in terms of, I've heard some people say there should be 4 and 4 in one swing so that you always know kind of where you stand on cases. And then, Kennedy's been the swing lately, but now it seems like it's 5-4 to conservative. It's been 5-4 liberal. How do you feel about replacing, having the pledge to replace a swing with a swing, a Republican with a conservative with a conservative, and a liberal with a liberal?
Well, certainly what has become more political is Congress, right?
Well, yes.
And so I'm not sure you could ever get Congress or a president to agree to that. Because, when even in the minority could think, well, when we get back, the Senate, we want to be able to vote for the people we think would do the right thing in interpreting the Constitution.
Right.
Well, I know we have to wrap up. I have one really silly question for you. I'm a huge Ruth Bader Ginsburg fan. How do I get her on my podcast?
I don't know. That's a good question.
All right. If you could think about that, I've been trying to figure out, obviously it was a shot in the dark, but I'm going to try. So I don't know if you have it. If you ever have any advice for me on that, I'd love to hear it.
Okay.
Even an autographed picture, maybe, if that's, something like that.
Well, Kit,
find somebody who knows her. That's
Yeah,
would be
yeah.
my
I
advice.
don't know anybody who knows. All right. Yeah, I'll have to search that out. I've seen her speak and stuff, and I've seen all the documentaries and movies on her, and so
Yeah, the
I just
film, the documentaries was really interesting, I thought,
Mm.
as was the film. But
and I recall the documentary. There was audio transcripts of her opinions and stuff, and hearing that, I was just riveted. Like, such a smart lady. I'm such in awe of her. So.
And funny, and really funny. Really, really good personality too, to boot.
And her trainer, and how she's called, the notorious with
RBG.
yeah, I love that. I mean, what a
Yeah.
sense of humor. So,
Yeah.
well, Kit, it's been awesome to have you. I feel like I really want to come. I want to have you come back on, talk about all the other amazing things that you've done. You've done so many, wrote so many articles and spoken about some such interesting topics. So we're going to have to bring you back on if you're willing.
Well, thank you.
to
It was really
cover.
my pleasure.
So, well, thank you, Kit. Thank you, everybody, for listening. If you can, hit that subscribe button. We super appreciate it. And until next time, we'll see you on the Defense Never Rest.